Hello, everybody, and welcome back to SEC Roundup. I'm Nick Morgan. I'm the co-founder of ICAN, Investor Choice Advocates Network, and the co-host of today's episode. I'm joined today by Sarah Heaton Concannon, who is a partner at the law firm of Quinn Emanuel, also their co-chair of SEC Enforcement Defense Practice, and a former enforcement senior member of the SEC enforcement staff. Sarah, thank you so much for joining.
Thank you, Nick. Good to be back.
And we're also joined by our guest today, who is Russ Ryan, well known to us, a friend of ICAN. Russ is currently senior litigation counsel at the new Civil Liberties Alliance, formerly partner at King & Spalding, and before that, an assistant director at the Division of Enforcement at the SEC, among other things. Russ, thank you for joining.
Thank you. It's always great to talk to you.
So we heard about a case that's been long brewing, and we're going to ask you some questions about that case. But to set it up properly, I think we need to get a little bit of context on SEC administrative proceedings, which have gone through a few runs up to the Supreme Court and had some significant Supreme Court rulings on that subject. For that context, Sarah, can you kind of describe in high-level terms, to set up Russ's description of his case, what an SEC administrative proceeding is and how they've fared in front of the Supreme Court in the last recent years?
So I'm glad you asked kind of what an SEC administrative proceeding is, because I was going to go back to deep history, whether you wanted to hear it or not, because it's actually interesting that the SEC administrative courts are not new. The SEC administrative courts have existed really from the inception of the commission 90 years ago. What has changed is over kind of the lifetime of the administrative courts, there have been various rulemakings, often in the wake of financial crises and other emergent events, that have led to a broad expansion of the SEC administrative authority, really culminating in kind of post-Dodd-Frank, a situation where it was almost indistinguishable, the powers that the SEC's administrative in-house courts had versus a federal district court. And that's what led to a lot of the constitutional challenges that we've seen over the last 7 years, which have given rise to the three Supreme Court cases that I'm going to talk briefly about today before handing it off to Russ. But so historically, just to go back, in the early years of the SEC's administrative courts, the SEC could only seek injunctive relief in federal district court. The administrative courts were essentially for proceedings against regulated entities like broker-dealers, that type of thing, with remedial sanctions such as trading suspensions and so forth. And then kind of in the wake of the 1987 stock market crash, which I think at least the three of us are old enough to remember, the SEC or the Congress passed the Penny Stock Reform Act. And the Penny Stock Reform Act at that point gave for the first time the administrative courts the ability to impose monetary sanctions, which was kind of a precursor to the cases that you now see, where the question of whether a monetary sanction is so akin to a penalty that it can only be imposed in a federal court as opposed to an administrative court. Then in 2002, following Enron and WorldCom and the tech crisis, SOX passed, and the Sarbanes-Oxley Act expanded again the SEC's authority to bar in administrative proceedings people from serving as officers and directors. And often we look at bars as though this is a nominal thing, but essentially a bar from appearing and practicing before the SEC for a lawyer who is an SEC lawyer, or from a accountant who is appearing and practicing as part of their practice, or from an officer and director of a public company, is an existential threat. So another form of penalty that was permissible in the wake of SOX. Then in 2010, this is the biggest expansion, which is Dodd-Frank that I referred to, which gave the SEC the ability to seek administratively before an ALJ, so bench trial, civil penalties against any person. So no longer just regulated entities and their affiliates, but actually anyone who was alleged to have violated the securities laws. So that set off a sea change in kind of the number and types of cases that were brought in the SEC's administrative courts. And before Dodd-Frank, it was about 60% of public company cases were brought administratively. Post Dodd-Frank, it rose to 78% of public company cases. And where for decades, the SEC had been doing things like 12J termination of registration, 12K trading suspensions, narrow actions against regulated entities, suddenly what you started to see is cases, true fraud cases, scienter-based fraud cases, but perhaps cases where the SEC felt like their proof wasn't quite as strong as they wanted it to be, being brought in the administrative courts for a home field advantage, as opposed to being brought in the federal district court. So that brings us to broken windows enforcement. I joined the SEC in 2016, which is when, we were actively bringing a great number of fraud cases in the administrative courts. I tried one of the last fraud cases in the administrative courts in 2016. And then, that gave rise to these constitutional challenges, because what people were encountering is now you've got a full-blown fraud trial in front of an administrative judge. Even setting aside the home field advantage, you lose the rules of civil procedure, which have some utility to us as trial lawyers. You lose document and deposition discovery, or at least full-blown. It's very limited motion practice in the administrative courts. And of course, you lose jury trial. And there's also a de novo right of appeal to the commission following an administrative case. So after you go through, you get an initial decision of an ALJ. The commission can completely revisit soup to nuts all of the evidence presented and reach the same outcome or another outcome before you have recourse to the federal courts. So not surprisingly, this caused some concern to people like Russ and others, which gave rise to the constitutional challenges, which brings us to Lucia. So Lucia was 2018. It was the first major challenge to the SEC's administrative courts, and it challenged the constitutionality of the ALJs under the Appointments Clause. So the question before the Supreme Court was whether the SEC administrative law judges are officers of the United States within the meaning of the Appointments Clause, such that they have to be appointed as senior officials by the commission or in certain specified ways. Apart from that, ALJs are employees. They go through the OPM hiring process just like the rest of SEC staff, or were prior to Lucia. And so that was the fundamental question. They're acting like judges. They're making decisions like judges. They're taking evidence like judges. And yet, they're employees of the commission. So in 2018, in a 7-2 decision, the Supreme Court held that, yes, in fact, ALJs are officers of the United States. And that led to, some new conduct on the part of the commission in terms of what it brought administratively. And also, essentially, they reappointed through the commission process all of the then ALJs. And they also gave people an opportunity who had cases pending on appeal to have their case retried before a constitutionally appointed ALJ. Not surprisingly, not everybody was super excited about the idea of retrying their case in front of the constitutionally appointed ALJ, one of whom was Michelle Cochran, which gives rise to the next major Supreme Court case in this space. So in Cochran, her fundamental challenge, offered the opportunity to retry her case. She said, no, thanks. Took her case to the Fifth Circuit and essentially said, Lucia looked at the Appointments Clause, but it didn't look at removability. You should look at removability as well. And you should find that because ALJs are not subject appropriately to removal, that this is also unconstitutional. The Fifth Circuit said, we're not even sure we can consider that issue, because the question is whether or not you have a right to appeal that constitutional issue, that kind of fundamental gating issue of, can I even be tried by an ALJ, until you've wound your way through the initial decision process, the commission appeal, et cetera. So basically, if there's not a final adjudication, can we decide that issue? So initially, the Fifth Circuit said, jurisdictionally, we are the question is whether or not, the district court had subject matter jurisdiction. And then the Fifth Circuit en banc reconsidered the jurisdictional issue, held that the Exchange Act did not explicitly or implicitly divest federal district courts of jurisdiction to hear these types of constitutional issues. And that went up to the Supreme Court. Supreme Court granted cert to consider that question. And in April of 2023, Cochran won her argument in front of the Supreme Court. Supreme Court held that she could bring a fundamental, even existential constitutional challenge in federal court before the full administrative adjudication. SEC once again reacted to that, much as they had kind of stayed cases and given people the opportunity to retry cases in the wake of Lucia. In the wake of Cochran, the SEC announced dismissal of 42 pending enforcement cases and unwound those, which, Nick, I think you and I had a conversation about previously on one of these webinars. And then that brings us finally to Jarkesy. So Jarkesy, the Supreme Court held that there is a Seventh Amendment right to jury trial for claims under the anti-fraud provisions of the securities laws where the SEC is seeking penalties. This fundamentally, I think we've talked about this before as well. Jarkesy is like a big problem and a little problem for the SEC, depending on how you view it, because in the wake of Lucia and the wake of Cochran, the SEC had already kind of returned to fundamentals. They had stopped trying fraud cases in the administrative courts. They had pushed almost all litigation into the federal district courts. And, so they were not seeking administratively to bring high-level scienter-based fraud cases against people for significant disgorgement and penalties the way they did kind of during the broken windows regime. But the question that Jarkesy sets up is where you have comparable things. So you have a regulated entity, a regulated person, an accountant, where, for example, the threat that's being posed is the existential threat of no longer being able to appear in practice before the commission, or there are significant penalties being imposed. Do I likewise have a right to a jury trial under those circumstances? So I think that's where, despite the fact that the SEC is retrenched quite a bit, where there is still the possibility of additional constitutional challenges and a further narrowing of the SEC's authority. Because also, I guess, the fourth case in the mix is Loper Bright, which is also now calling into question fundamentally whether or not the SEC in these administrative determinations is entitled to the same sort of deference that it used to receive. And kind of these four cases in combination really do draw into question kind of what is the future of the administrative courts. But as you say, the interesting question for Russ is he's got a live action in front of the SEC. And, despite all of the changes that we've seen and kind of the SEC pivoting to try to reduce the risk in this context, it sounds like Russ is still, and his client, more importantly, still very much kind of in the crosshairs of, are these appropriately procedural and, being approached in the appropriate way. So
Right.
that was a too long-winded answer to your question, but hopefully a good setup to the substance of the conversation today.
Yeah, absolutely. Not too long-winded at all. I think necessary to understand what Russ is about to describe. And if I could vastly oversimplify, the SEC administrative hearing process has really been under fire at the Supreme Court. There have been serious questions raised about the divisions between the three main actors, which are the commission itself, the five, or currently four, politically appointed commissioners, the enforcement division, the staff of employees who are prosecuting the case, and the administrative law judges, who are, as you say, employees of the Securities and Exchange Commission. So given that scrutiny that's been applied to this process and the separation of those three players, I found what's going on in your case, Russ, to be completely shocking. So maybe we can, with that background, turn to you. Maybe tell us, who is your client? He's been in the crosshairs of the SEC for a long time. And what just happened in your case that is particularly shocking in light of the history Sarah just outlined?
Yeah, thanks, Nick. Yeah, if I could just start by saying thank you, Sarah, for that great background. Um, and most of the cases you mentioned, my organization has been in the thick of the new Civil Liberties Alliance. We actually represented Ray Lucia after his Supreme Court case. We represented Michelle Cochran for most of, including the Supreme Court case. And in the Loper Bright case, we represented Relentless, which was the companion case. So I appreciate that. And I agree with pretty much everything Sarah said. But just one thing that I'm trying to get the defense bar away from, which is conceding the lexicon. For example, I never refer to these as administrative courts because they are absolutely not courts in any sense of the word. It's um, lexicon used to mislead the public, I think, and calling these administrative law judges, which is the statutory term, but in calling them administrative law judges, it's a purposeful attempt to mislead the public into thinking these people are judges. They are not judges. They're civil servants that are appointed by the SEC commissioners as employees in the executive branch of government. They have no resemblance other than what they purport to do during these proceedings. They bear no resemblance to an actual federal judge who's been appointed by the president, vetted by the president's staff, then vetted again by the Senate and confirmed, and then has life tenure. The ALJs at the SEC have none of those features. So I just recoil from the notion that we call these courts, and I even don't like the term administrative law judge, so I immediately abbreviate it to ALJ and go from there. But back to my case. If you thought that a few Supreme Court decisions and maybe a landslide election would bring some fairness and humility to the SEC's administrative process, well, think again. Here we are. We're 6 months into the new regime, and it's just business as usual, other than the fact that there are very few cases now pending before the ALJs. By my count, there's as few as 2 and no more than 3 or 4. Contrast that to the period Sarah was talking about, where these ALJs had dozens of cases pending before them, each of them, and they were cranking out anywhere from 50 to 100 initial decisions on the merits per year for several years there. There hasn't been an ALJ decision on the merits, as best I can tell, in probably 2 years now. So just the whole process has ground to a halt, and there's only a handful of these cases out there. My client's case is one of them. It's a case against the Reverend Father Emmanuel Levelson. They've been hounding this guy since 2014 because of a few things. He criticized a public company in some written reports issued under his own name after he took a short position in the stock. So I think collectively it's 56 pages of written reports, and he went on some online interviews that probably totaled about an hour's worth of airtime. So the Division of Enforcement took 3 or 4 years to investigate him. It was a scorched earth investigation. In 2018, the commission finally sued him in a federal court in Massachusetts and trumpeted the case as this massive short and distort scheme where, he made all kinds of money. People lost all kinds of money. Unlike the vast majority of SEC defendants, Father Lemelson defended himself. I should say we were not involved in the underlying case at all in the federal court in Massachusetts. He was ably represented by a really great litigator in Boston named Doug Brooks at the Libby Hoops firm. So I can't take credit for what happened in that case, but essentially they went to a jury trial, a real jury trial in front of a federal judge, and the SEC basically lost the entire case. All that was left when all the dust settled was 3 snippets within his reports, his written reports, both of which didn't even relate to the company he was reporting about. It was a sort of an affiliated non-public company that he made two comments about. And then in the online interview, it was sort of a he said, she said, and the jury apparently believed, the other person, not Father Lemelson. But in any event, it was three isolated statements among this vast body of work criticizing a public company, basically core First Amendment. Nevertheless, the jury found those three sentences were untrue or contained omissions that made them misleading, so forth. But the rest of the case was completely thrown out. All the fraud charges, other than this three statements, thrown out. Nevertheless, as night follows day, there's no thinking involved. They get an injunction from the district court, which, by the way, rejected 90% of the remedies that the SEC was looking for, too, even though they just lost the jury trial and barely scraped by with a couple of relatively insignificant statements that the jury found untrue. They demanded over $2 million in financial penalties, permanent lifetime injunction, the usual stuff, disgorgement of $600,000 or so. The district judge basically rejected all of it, imposed a 5-year time-limited injunction, only $160,000 in penalties, and said no disgorgement at all because there was no illicit gain and no harm to investors. So still, as you know, the way the process worked, both of you know this, they got an injunction. It's basically, in my opinion, a completely unenforceable one because all it says is he's enjoined from violating 10b-5 and Section 10b in the future. It doesn't even go through like the process of like cutting and pasting from the statutes. All it says, it's one sentence. Wow. So, but it's an injunction and it relates to the purchase or sale of a security. So, of course, as night follows day, the division files an administrative proceeding, which, by the way, I do not think they needed to go to the commission to get, because the secretary's office has delegated authority to issue follow-ons as long as it was approved back when the original complaint was filed back in 2018. So here we are in 2022. The case is completely different than what the commission approved in 2018. It's a mere shell of what they approved. And yet, I think the secretary then issues the order instituting proceedings based on the injunction to see whether Father Lemelson should be barred for the rest of his life from the entire securities industry.
Right.
So that case now has been pending yet another 3 years. So all the conduct that this relates to dates all the way back to 2014. Nothing after that. But here we are in 2025. The hearing is scheduled to start in July. But we're in a situation where we're in one of these, they call them follow-on proceedings. So I don't know where you want me to begin with what's wrong with it, but this particular proceeding has everything that's ever been wrong with administrative prosecution. So
well, I would be interested to hear all about all of that, but I think for purposes of today, if you could focus on what happened with regard to the staff acting without commission authority, that would be, I think, quite interesting. So
yeah, but
one aspect that's going on.
So yeah, so in the course of this proceeding, the staff, as night follows day, filed for summary disposition, which is the essential equivalent of summary judgment. And as best I can tell, they do it literally in every follow-on. And until this case, the commission grants it in literally every follow-on. Like there's no exceptions to that. So in this case, while that was pending, and we were just sitting around for years, as you know, The SEC is not exactly on the ball when it comes to deciding the cases before it. I've called this the Hotel California. You get in, but you can never get out. So,
Okay.
so that motion was pending for years, and then we got involved in the case and said, "Wait a minute, this is a follow-on proceeding that the commission itself is the adjudicator." Whether or not there's an ALJ in the middle here, at that point there wasn't. But the SEC is the adjudicator. They're supposed to be fair and impartial and have no predisposition about the outcome of this case that's pending before it. And yet, this is the same commission that's been suing Father Lemelson in federal court since 2018 and filed dozens of pleadings, complaints, press releases, and the like that have essentially demonized him and told the public this guy is a menace.
It's not exactly the impartial arbiter.
Yeah, you could. It's kind of when you stand back and think about it, it's crazy. I mean, you're being charged in a proceeding where your judge is the guy who was just suing you for the last 5 years in a related case.
Yeah.
And you're supposed to think, oh, well, I'm going to get a fair shot here.
Right.
Not surprisingly, every single follow-on, as best I can tell, in recent memory, in years, has ended up in a bar or suspension. No exceptions. So that's where we were then. Fast forward to 2025. And by the way, I'm only making a limited appearance in that case. We filed a motion to dismiss on behalf of Father Lemelson, but I'll tell you why we did that. In addition to all the constitutional problems of the case generally, the division, after the case was dormant for these 2 or 3 years while the summary disposition motion was pending, ultimately, we asked for a stay because we'd sued the commission in federal court here in D.C. to stop the proceeding on the grounds that it's unconstitutional. Shortly after we did that, we asked the commission to voluntarily stay the proceeding so that the courts would have time to determine whether it was even constitutional. The SEC ultimately said, "Too bad, we're going forward," and then. But it denied the motion for summary disposition, which is unheard of, basically.
Yeah.
And then assigned it to an ALJ, which is very rare these days in the post-Lucia era. So there we were before an ALJ, and we then amended the complaint in federal court and asked for a preliminary injunction from the federal court. 2 weeks later, all of a sudden, the division decided we need all kinds of discovery. And so it just started throwing all these subpoenas out there against Father Lemelson. Most of the information, as I think I mentioned before, had nothing to do with the underlying case. It was effectively starting a new investigation of, it's sort of reminiscent of the notion of, show me the man, I'll find you the crime. So they're basically opening up a new scorched earth investigation to try to find something, anything to throw against the wall against him and see if it sticks.
And Russ, just for clarification, these subpoenas they're sending out are not investigative subpoenas.
Correct.
Would do if they were, conducting an investigation. These are subpoenas within the administrative proceeding itself. So again, I know this is not a court proceeding, but if you were in court, you could issue subpoenas to gather information for that proceeding. So this is a subpoenas within the administrative proceeding.
Right. Either party, if they want a subpoena, has to ask the ALJ to issue it. So it's a subpoena issued by the ALJ, not by the Division of Enforcement, which is the typical subpoena in an enforcement case, in an enforcement investigation. Now we're in a proceeding where everything's supposed to be on the level, public. The ALJ is in charge, not the division. They're just a litigant. But they convinced the ALJ to issue this subpoena, although in fairness, the ALJ did pare it back and take out some of the more outrageous stuff. But it still went well beyond anything remotely relevant to the follow-on proceeding. So Father Lemmels had said, if you want this stuff, come see me after you've got a court order enforcing the subpoena. As you know, SEC subpoenas, no matter who issues them, are not enforceable. They're essentially polite voluntary requests unless and until you get a court order. So we assumed that the division, if it wanted to go to court, would go to the ALJ or to the commissioners and say, we need you to file a subpoena enforcement action. And the division didn't do that. They went straight to court without involving the commissioners at all. And they claimed they had delegated authority based on a rule that gives them delegated authority to file these lawsuits, whether that's a wise thing or not. But as long as it's an investigative subpoena issued under a formal order of investigation, that delegation does not cover ALJ subpoenas issued in the context of an administrative adjudication. And so, in our view, it was basically an ultra-virus lawsuit. As soon as we found out they did it through delegated authority, we pointed that out to the division staff and the court. And a week later, the commission abruptly just dismissed the case voluntarily.
Can I at the risk, I don't want us to bury the lead here. I mean, what you just said, you said it like a lawyer would say it. That's shocking, Russ. Like,
it was a fake lawsuit, a fake SEC lawsuit.
You've got staff members in the Division of Enforcement going into federal court and essentially initiating a lawsuit to enforce this subpoena in the administrative proceeding, and they never asked the commission for permission. I mean,
correct.
I'm just shocked. I'm just astounded. It's crazy. It's so I'm not surprised that they withdrew it. But I'm sorry to interrupt your story.
What's even crazier is the commission seems either unaware of it at this point or unconcerned, because nothing has come from the commissioners yet that says, wait a minute, what's going on here? It's just full steam ahead. And I don't know if the staff is not telling the commission what they did, first filing it without checking with their client and then dismissing it without checking with their client. Right. Or if the commissioners are well aware of it and it's a big yawn.
Yeah.
But to me, this is unprecedented and just, I've never heard of this before. It's such a complete irregularity that you would think this would behold the presses. How could this possibly happen? And what are we going to do to clean this up?
Right. Well,
now it's crickets chirping.
Yeah. So one possibility is that the commission doesn't even know, right? So describe what you did next. You filed a motion, right?
Yeah, we filed a motion to dismiss we filed it in the administrative proceeding, but we specifically requested that, given the seriousness of what is at issue, it should go straight to the commissioners, especially because there's this impending hearing in early July that the ALJ and the division just adamantly refuse to postpone, even though there's no conceivable urge. I mean, we're talking about 2014 conduct in an AP that's been pending for 3 years. But for whatever reason, they're hell-bent on proceeding on July 7th. And so we said, you need to decide this, and you need to decide it promptly, and let's have the commissioners focus on this. And we basically said, this is a serious breach of protocol, but there's more. I mean, the motion to dismiss is in two parts. One is because of the fake lawsuit in federal court. The other is, at the same time they were doing this fake lawsuit, apparently a staff attorney in the enforcement division was transferred to the chairman's office to become counsel to the chairman sometime around, I don't know who it is, but early August. And for a period of a month after she went from the division to the chairman's office, she was still getting internal division emails that were flowing freely to her, including some emails that talked about Lemelson's case. And so Our motion says this is at least as bad as the control deficiency 2 years ago that resulted in the 40 some dismissals that Sarah mentioned. And again, we've got the commission just seems to be either unaware of what's going on or absolutely unconcerned about it, which is just shocking to me.
But interrupt you one more time to highlight how crazy this is. So if we were in federal court, this is the equivalent of the prosecutor sharing ex parte communications with the judge's staff or even the appellate court staff, I guess, is the commission. But
yeah. Picture someone from the prosecutor's office going to become a law clerk for the judge presiding over the case against you, and still getting emails from the prosecutor's office while your case is pending before the effective equivalent of the chief justice of the court that's going to decide your fate. It's insane, but yeah.
And it's entirely possible, like we don't know, I guess. It's entirely possible the commissioners are unaware of all this because it's got this barrier of the staff and the ALJ that you have to go through them.
Yeah. In our motion, we do have a section that says it's entirely possible that the commissioners have not even been consulted about this case since at least 2022 when the staff sought its remedies in federal court in Massachusetts. I think at that point they would have had to go to the commissioners. If I'm wrong, if they didn't, then they probably haven't visited this case since 2018. But like I said before, they likely didn't need to approve the order instituting the proceedings in 2022 because the secretary has delegated authority. They probably weren't involved in any of the preceding motions in the administrative proceedings, some of which we asked for interlocutory review. But again, there's other delegated authority to the Office of General Counsel to deny motions for interlocutory review if the ALJ did not certify it as for so even those probably didn't get commission attention. Right. And now we know to a certainty that when the division filed its fake lawsuit, there was no commission involvement. So, it is a situation where, you got to wonder how much actual oversight and supervision by the politically appointed commissioners is actually going on in any of this. And on top of that, from a litigant's perspective, a respondent's perspective, it's like the part in Kafka's The Trial where he's talking. I can't remember which character he was talking to, but he says, "Yeah, you never get to meet with the real decision makers. You spend your entire life being, harassed and by these lower level people. Yeah, they're up there. They make the final decisions, but you never really get a chance to talk to them. So all this delegated authority just shields the staff from any real meaningful oversight.
Or instances where the staff disregards the requirements to talk to the commission, as in
yes, that's what we have here.
Yeah, and so I think there's a popular misconception that you have an election, there's a change in the makeup of the commissioners, and then everything changes. And certainly there's some evidence of change in other cases unrelated to yours, in crypto cases, some, hedge fund case. But for most of the cases, the staff kind of just continues doing what it was doing before, or maybe even worse. So
yeah. I'm hopeful that eventually this gets the attention of the commissioners and they are appropriately shocked and not happy. But so far, that does not appear to be happening. And the fact that it's crickets chirping is a matter of, there's no disclosures that the commission is doing any kind of internal inquiry on any of this, suggests that either the commissioners remain unaware of it or are, for whatever reason, unconcerned. And, but that's where we are right now.
So you've got your pending motion to dismiss in the administrative proceeding. You still have the district court action, or is that now resolved?
The district court dismissed the complaint in late May.
Okay.
We filed a notice of appeal, so we think the district court got a number of things wrong.
Okay.
But that's going to take some time to appeal that.
Right.
And so we'll see. I mean, there's a lot of stuff going on. We still got a motion for Equal Access to Justice Act fees that the district court in Massachusetts originally denied, but the First Circuit a few weeks ago reversed that and remanded it back for further proceedings. So we'll get another shot with the Massachusetts District Court
Yeah.
to award fees. Now we're also exploring our options as to whether we can get sanctions or fees for the fake lawsuit.
And with all that going on, you have a hearing date in front of the ALJ?
Yes, July 7th. Although again, our limited appearance doesn't cover that. So Doug Brooks at Libby Hoops will be taking the lead on that. And I think Father Lemelson's in good hands here.
Right.
So
I'm just amazed, Russ. We'll leave it there, but obviously in the next weeks, months, there are likely to be things happening in one of the various of the 3 rings of your circuits. So good luck on that. Thank you for joining us. We'll wait to see what happens. Sarah, thank you for co-hosting today's episode and giving us that wonderful background on the SEC's administrative proceedings and the constitutional infirmities. For the rest of you, please join us on the next SEC Roundup. If you want more information about ICAN, go to icanlaw.org, and we'll see you on the next SEC Roundup. Thanks.